Hello, I'm Jeff Cusson with Saunders Real Estate. I'm an agent on the East Coast of Florida. And I'm talking today with Michael Minton with Dean Mead Law Firm about the topic of public-private partnerships. So, Michael, that's been a topic in the news and with a number of our landowners. Can you share a little bit of the background of it and what is exactly Section 118?
Yeah. Thank you, Jeff. Yes, I'm Michael Minton. I'm the past president of Dean Mead, and I chair the agribusiness industry team for the firm. And our firm is a large percentage of our lawyers are tax lawyers, so we do an awful lot of tax structuring and tax planning. And there's a basic premise of tax law that if you provide something of value to someone and get something back of value, you had a taxable event. You've had a realization and a recognition event, unless there are exclusions or exemptions that allow you not to recognize that gain, or a deferral mechanism, which you deal with 1031 transactions,
right.
So that's a deferral mechanism. Well, in the corporate world, and this applies just to corporations, when there's a contribution to capital to a corporation and a shareholder gets stock back, there's an exemption that allows the corporation not to pick up and pay tax on that contribution, because even though they gave stock back to the shareholder. That's Section 118.
I see.
Section 118 also historically provided that if a corporation received a capital contribution from a governmental entity or a chamber of commerce or some quasi-governmental entity, and it used those funds for capital improvements that primarily had a public benefit, then that was not income to the corporation. Well, when the Tax Cut and Jobs Act came out in the fall of 2017, one of the changes that was made was Section 118. And there was an effort to try to address what was perceived to be a wrong use of public policy to encourage companies to move from one location to the other, and an abuse of that Section 118. But when they repealed that exemption, they also inadvertently changed the taxation of public-private partnerships. So many times when you deal with a public-private partnership, you have an individual landowner agreeing to do certain improvements on their property that allows for a public benefit. In our world, it deals with a lot of our water projects, where you have landowners who are willing to allow their land to be used to store water that has a public benefit, but there are certain capital improvements that have to be made, and there's certain management costs that go along with it. Historically, before the change, if that taxpayer was a corporation, the money they got from the government for making those capital improvements were not taxable income. It was a capital contribution under Section 118. Post-Tax Cut and Jobs Act, it became a taxable event for the corporation to receive those monies. Now, there is a grandfather clause, so we've been able to protect old projects under that grandfather clause. It deals with different types of projects. But going forward, it's an issue. And the difficulty is, in one breath, you have the change of the Tax Act taking place, but in the next breath, you have government saying, we have a huge need for improving our infrastructure here in the States, and it's $1 trillion infrastructure project. And we're going to undertake it by committing $250 to $300 billion of federal dollars to be used to encourage public-private partnerships to go out and do these infrastructure improvements. So as we've spent the last year trying to point out to our congressman, that's a bit of a disconnect for you to, on one hand, say we're going to fix all of the past infrastructure issues we have in this country with public-private partnerships, and in the next breath say, but we're going to tax the federal share of that money that goes into the public-private partnership. That's what we're trying to address with this.
Well, good. Well, it sounds like a worthy cause. Now, would that affect even like on a small-scale projects like growers that are working with the NRCS on improvements to their property as well?
There are certain exclusions for certain type of water projects. So as long as you have certain provisions in there that deal with, for example, if it's part of a BMP project, those things are still protected under under the grandfather provisions and certain other exclusions that are available in other code sections. But, you know, it is an issue that needs to be addressed by landowners, especially corporations.
Okay, well, it sounds like a very complex bill, and it had some inadvertent consequences. While there were some very good things that went along with the tax bill, there were some inadvertent consequences that were not as positive.
Exactly, Jeff. As we experienced when I was visiting with the tax policy writers for the Senate Finance Committee and the House Ways and Means Committee discussing these very issues, they readily recognize that this change is an inconsistent policy statement when you couple it with the administration's desire to address our deferred maintenance on our infrastructure through public-private partnerships going forward, that this change in the Tax Act is totally inconsistent with that. And in fact, they suggested that I talk to the administration about remedying that when he comes forward with a plan for infrastructure improvements and how they finance that to make public-private partnerships not be a taxable transaction going forward. That's easier said than done, but that is one of the issues, one of the remedies that came about as a result of our meetings in Washington when we were addressing the Section 118
Well, thank you for
problem.
your work on that important topic. And if our audience has any contacts with their congressman, that may be a topic that they could bring up for discussion.
Absolutely, and it affects more than our agribusiness clients. There were a number of other interests involved. For example, utilities. There were a lot of developments that relied on utility prepayments that now were subject to being taxable to the utility if it wasn't a publicly regulated utility. Those costs were just being passed right on to the house buyer. So that tax increase just increased immediately the cost of the utility. Shopping centers, a number of shopping centers have to make infrastructure improvements at intersections and things of that nature. So there's a broad array of potential projects that this tax change affects, and hopefully in the future we'll have a chance to revert the tax consequences back to something that is more consistent with the policy statement.
Okay. All right, very good. Well, thank you again, Michael, for your comments and sharing your experiences with us. If you have further questions, we can contact you
Absolutely.
At Dean Mead Attorneys. So.
And we have information on our website, white paper dealing with this issue, and we'd be glad to address any questions that come up. And, tax attorneys can find ways around these issues. As I shared with some of our congressmen when I was up there, I said, gentlemen, we could work around it, but it's more expensive for our clients to have workarounds, and it's not as certain as the black and white we had with Section 118. In fact, I had one congressman look at me and say, well, why are you here? It's more money for you as a tax lawyer to do the workaround than what it was before. I said, but it's in our client's best interest to have it be black and white, to not have to do a workaround. Yeah. But as we currently are addressing, we are finding creative ways to yield the same tax consequences.
Good, good. Very complex issues. It's good to have the right people in their court. So thank you, Michael, very much.
Appreciate it.